the worm, computer virus, was named Morris. The worm spread swiftly, effectively crashed the large number of IT systems around the world. It was written by a university student, graduate student. And since at the time, 1988, internet was a very small scale network. Only 60,000 workstations are connected to this network. But this computer viruses was very effective. So it succeeded to crash 1 in 3 computers at the time. And because of this, internet at the time stopped to function. And following this incidents, part of the US Department of Defense decided to setting up a center to coordinate the communication among experts during cybersecurity incidents, during emergencies, and to help prevent future incidents. And this center was named the CERT Coordination Center, or CERT-CC, and it was the very first computer emergency response team in the world. And it was 1988. So after 30 years has passed already. Now we have more than 500 CSERTs around the world. And JPCERT is one of those. I think I see Jin Hyun Cho from Korean CERT participating in this session. But CERTs are everywhere. Some work for national government, some work for private sector. And CERT itself requires the international cooperation because cybersecurity incidents often are international issue. We see attack from Brazil or from the United States very often. So since the beginning, CERT start to expand CERT wanted to corroborate other CSERTs in other countries. It then lead out to a formulation of regional or global association of CSERTs. First, for example, Forum of Incident Response Team. This is for now the world's largest CSERT community. Any established team can be part of this membership organization. For this occasion, Asia Pacific audience, I think it is more that the AP CERT, the regional CSERT collaboration is more relevant or more important. AP CERT was founded in early 2000. And since then, AP CERT now have 30 member teams from 21 economies. Pretty much almost all Asian countries joined this group, except Cambodia and except economy like Cambodia or Nepal. Now, if you are coming from the national security field or international politics field, you may be very interested in, you might be interested in, Hong Kong, Macau, Taiwan are the very legitimate, actually one of those founding member of this community. The governance of cybersecurity, I would say, the governance of cybersecurity is very much on the foundation of internet governance. In the field of internet governance, it's a community to keep universal or global network up and running, and we do not care. We have not cared about the political side of this business. So in internet governance and cybersecurity governance, we see even Chinese experts accept the accept their counterpart in, for example, Hong Kong or Taiwan. And as a compromise, we do not use the word country. So we have 30 teams from, not from 21 countries, but 21 economies or regions. And CSIRT was meant to be respond the cybersecurity incident. It then, as time passed, has been tasked to additional roles. For example, some of CSIRTs provide the product vulnerability, software security hole assessment. Some of them provide the technical training for engineers. Some of them provide the penetration testing service for their constituents. So 30 years has passed. The role of CSIRTs are expanding, and some of the CSIRTs provide the full range of services, and others are not. So the CSIRT community itself are very diverse. Now, how this community affect or interact with bigger policy discussion or governance? There's an important milestone back in 2015. If you're following the UNGG, Group of Government Experts for, I forgot the exact name, UNGG for Cyber, ICT something. So the report from this group of government experts back in 2015 argued that state should not conduct or knowingly support activity to harm or to attack the information systems of CSIRTs over another states. So any country should not attack to CSIRTs over other countries. Vice versa, states should not use CSIRTs to engage in malicious internal activity. So if you are, any states should not let your CSIRTs to attack others. So clearly from this agreement, by the way, this was proposed by, this was the outcome of GGE meeting. It then tabled to General Assembly, and with the consensus, this report was passed. So at least we can say this is the very stable consensus of all UN member nations back in 2015. But it is clear international community accepts CSIRT to be, I think, communication channel. And even in time of crisis, like Cuban Missile Crisis, in time of crisis, CSIRTs are expected to exchange or share information, even with non-friendly or non-strategic partner countries. So that's an additional expectation, but as we, for example, JPCERT, I would say 99% of us are we are engineers by training, and the political implication are not very much, appreciated. Our business has not changed much. We still continue to work, help, victims of cybersecurity attack. So that's my first point. Now move on to the second one, the threat landscape. It is very difficult to explain the threat landscape to, this distinguished, however, diverse community, the diverse audience. And so for today, I'd like to briefly explain how we as JPCERT, Japan Computer Emergency Response Team, share the threat information. I think You may not be very familiar with the word IOC. IOC stands for Indicator of Compromise. Typical IOCs can be IP address or hash value of a file, or domain name or URL, signature of antiviruses. So all these technical information associated to one hacker group or associated to any sometimes criminal groups, sometimes individuals. We need IOC since for last decades, the technique hackers are getting very, very smart, and even even professional like us cannot be cannot be very comfortable in identifying attack to our organization. On average, it took 2 years for us to identify the breach to our organization. When we JPCERT come to a potential victim of a cyber attack, often the case, the log tells us this has occurred 2 years before that day. So that's the unpleasant fact we are facing right now. And to help this situation to identify attacks as early as possible, we need IOCs. This is an information which we can search for existing system, search for existing environment. For example, if you know the IP address which a cyber criminal group is using, you can then search proxy logs, web server logs, email server logs with that IP address. And so if we have this type of hint of an attack, the identifying attack is way more easier. So that's why IOC is important. Now, how we can share the IOC with whom, by when, is more important topic. So in our case, so this may sound a little bit extreme to you, but when we identify, for example, DCAF's system is compromised. It is very highly likely the entire system of DCAF is compromised. And when we, for example, when JPCERT asks someone at DCAF to check, for example, the logs of web server, since the attackers or criminals are monitoring all these activities very carefully, they then decided to move to next target. We see that kind of very sophisticated and mobile attackers very often. That's why we should not use emails in the time of emergency. We need something else. Often the case, the most common choice for us is not so special. Some Japanese company, so security managers of Japanese company hate to receive phone call from us, because in most cases that's the phone call will provide them, hey, your computer is badly compromised. So phone call is the one way. The other way we're using right now is a special communication website with additional or special encryption and few other security mechanism. This is kind of like is a little bit. It looks similar to Facebook, but not as funny or as interesting as Facebook. But it's more special. It is specialized to exchange IOC and related cybersecurity information. So we have that kind of system. Provide the username or username password credentials to. I cannot give you the exact number, but to many Japanese critical infrastructure providers. And the benefit of sharing information with trusted group is if we share the IOC, which we exfiltrate or which we receive from, let's say, commercial bank A in Japan, let's say Tokyo Bank. If we share the IOC from Tokyo Bank compromise or Tokyo Bank cybersecurity incident, in most cases, other financial institutions in Japan identify the same group attacking their own system as well. So the sharing information must understand how attackers trying to penetrate the system sector-wide or sharing information within a particular sector has to be or has been provenly effective. So my final slide, way forward. I think there are hundreds of different approaches to address the cybersecurity issue we are facing right now. One very common advice for everyone is inclusiveness is the key, especially the private sector, a key to success. If you are from the biochemical weapon field, nuclear proliferation field, that's fine. You know, government can control, let's say, 95% of industry. In cyber, that's not. You may work with Microsoft, Amazon, or Alibaba, and then many other stakeholders. So have to be inclusive, requires the different way of approach. Sharing IOC is very powerful. However, it cannot be fully automated. You really need someone to interpret the impact of those IOC to your own organization. This is pretty much similar to lethal autonomous weapon system requires the human intervention before pulling trigger. We cannot ask AI or system we cannot let them decide the very critical decisions. That theory applies to cybersecurity as well. And IOC analysis must be done by human, part of it. And for the from the experience of serving as a secretariat for JPCERT, the Asia Pacific regional CSERT community, we see increasing tension even between members. In the past, let's say 20 years ago, it was very peaceful group of engineers talking about how to code, how to crack down, and how to solve the technical problems. Now, cybersecurity problem is becoming a political issues. We need different type of skill set. what is common, what has not been changed at all, is trust in a human level. So to me, the most I appreciate my counterpart in other Asian countries. I hope they also recognize me as a resource person sitting in Japan. And that's how CSET community works. Thank you very much. And I'd like to stop here.
Thank you, Dr. Koichiro. You were exactly on time, so thanks a lot. So it's been quite interesting the way you presented it. I know DCAF has been working with CERT in some of the Western Balkan countries as well under its big cybersecurity program. So it is something we want to introduce to our partners in the region as well, so that as Dr. Koichiro has said, there are a lot of national CERT institutions in all the Asian countries. So it would be interesting if our partners decide to kind of work on the cybersecurity issue in future, then they will definitely could easily get in touch with them. And of course, DCAF will facilitate those kind of discussion if we were able to generate similar kind of program for our larger Asia Pacific region. So this is something that we'll keep discussing with our partners in future. But now I would like to move on with our next presenter. But and just going back to the Dr. Koichiro presentation, if you have any question, please note it down, or you could always send it to the chat box, and then we'll take those questions to the Q&A at the end of the Dr. Kah-Kin presentation. So with that, now I would like to invite Dr. Kah-Kin for his presentation. So his presentation will be roughly over 45 minutes. So he will be focusing more on how the international law will be applied in the case of the cybersecurity, more from the experience from the Asian countries. So with that, Mr. Kah-Kin, the floor is yours. Yeah.
Thank you, Rohit. Can you guys see my slide? And can you hear me well?
Yep, it's good.
Perfect. Thank you, first of all, DCAF, for giving me the opportunity to present here. I'm going to be talking about international law positioning by states and more towards the lesson learned perspective. My name is Kah-Kin Ho. I know at least one person in the audience here, so I do not know most of you. So what I'd like to do up front is to spend 1 minute, speaking to you about my background. I spent 27 years in the private sector, so I left the private sector going back September 2020 to work at the intersection of international law, technology, geopolitics, and national interests. So I'm the strategic security consultant since September 2020. Before that, I spent 4.5 years in FireEye. You might know FireEye being the premier, American cybersecurity company. I was the senior director for Europe, Middle East, and Africa for their government business. And before that, I spent 20 years at Cisco, right? I'll say after 9/11, basically my career changed dramatically, because since 9/11, I only have dealt with issues around national security and defense and intelligence. Right? In the past, I spent many hours on battlefield communication system. That has been my subject matter expertise. Going back 2009, I spent time in the War College, focusing on counterterrorism research. This is still an area of interest for me, especially when it comes to things like radicalization and intelligence failure. I served some time as a lecturer on security strategy and policy at the ETH Zurich here, which is where I'm actually based. So let me just start by saying that you might have noticed that some states have already come up to articulate their government's position when it comes to how international law applies to cyber operations. Many states, as I know it, as I've been working with them, are also preparing to do so. And I think this is critically important, because going forward, what you're going to see is that there's going to be emerging cyber powers, right? There's going to be more and more countries with offensive cyber capabilities coming up here. I actually see at least 3 benefits for states to actually come up and articulate their position on cyber operation. And the first one actually has to do with enhancing the law's deterrent, right? So no longer do you want to look at, cyberspace as the wild, wild west, right? There's actually rules in there. So enhancing law's deterrent is going to be quite important from my perspective. And because these rules are actually going to be known by different people, right? As more states come up to articulate their position, I think it has the potential to also avoid unintended escalation, right? And overall, it will bring a level of stability in cyberspace. Now, admittedly, articulating international law and how it applies to cyber operation is not easy, right? Because international law doesn't stand on its own. It is, at the intersection of so many different things like geopolitics, national interests, technology, and of course, the role of private sector. What do they do when it comes to, what will be their role when it comes to international laws and norms, right? So what I'd like to do in this presentation is to talk through how the different factors that I just talked about actually, influence a state's position when it comes to, their position in, how international law applies to cyber operations. There's going to be, I think, 9 lessons learned, so I'll try to go through this in time. Rohit, if I go through 5 minutes later, I hope that's still okay. But I'll try to keep everything to be in time. Now, the first lesson learned that I, often talked about with different governments is this one here, and that is states actually have a very difficult balancing act that they have to worry about. Because on the one hand, they want to have this thing called freedom of action. They want to be able to, because in the geopolitical situation, they want to be able to do stuff to influence other states, right? So this freedom of action is going to be pretty critical for them. On the other hand, they also have the issue of, I want to avoid harm to my state as well, right? So you see that, they're constantly juggling between these two, opposing needs, right? And usually when it comes to strong states, they maximize both sides, right? They maximize the freedom of action. They want to also maximize the harm avoidance. A key example here is basically, you can look at nuclear states, right? So number of states have nuclear capability, right? So that gives them freedom of action. They want to maximize that, right? They want to be able to use that to influence what other states may do, right? But at the same time, they are also trying to avoid harm to themselves. And how do they actually do that? Well, they do that using, a treaty, a non-nuclear proliferation treaty. That is to say that, hey, we are the ones with nuclear capability, but the rest of you guys, you don't need to have that, right? So this is their way of, maximizing both sides of this side of the spectrum here. Now, there's also a different type of states, and they, they do not want so much about freedom of action, right? And, they want to prioritize more on harm avoidance. I would say that, usually weaker or smaller states would like to do that, right? So I can, for example, look at, smaller states, and when they are in the UN, the way they speak about, how international law applies, they are more focused around how do I prevent stuff from happening, rather than saying, hey, I want to be able to shape it in a way that I can do things to other states, right? And of course, there's also a classification of state that do not care so much about harm to their states, but they want to prioritize more on freedom of action, right? So usually, this will be the rogue states, right? These states are basically pushed to the corner. They don't really care so much about harm anymore. I just want to be able to do stuff to other people. So as I go through this thing with different governments, I often ask them a question that is, where does your state stand? Okay, and more importantly, what would be ideal for your state? And sometimes when I ask this question, I get this blank face coming back at me and say, I don't really know, because our leadership has not really articulated that for us, right? And I suggest that, you know, this will be a great question for you to ask as well, as you're trying to shape, you know, what your states are going to be, you know, taking in terms of the position on international law when it comes to cyber operations. Now, as I spent 27 years in the private sector, I cannot, you know, ignore the private sector. So I'll speak about the private sector. And this one here is the private sector international norms play, right? Maybe some of you have heard about the Digital Geneva Convention, and this is basically promoted by Microsoft. Basically, it's used to shape norms of behavior, states' norms of behavior during peacetime. There are some 6 elements that you see here, but I want you to focus on the first one because that's what I'm going to be focusing on, right? The first one talks about, you know, no targeting of tech companies, private sector, or critical infrastructure. And the key there is actually critical infrastructure. So as you know, listen to my presentation, I'd like to ask you this one question. You know, if you know about this thing, what do you think about it? Is this a good thing for a private sector company, Microsoft, promoting that in the peacetime, states should not be targeting critical infrastructure? I ask this question because this is the most appropriate time to ask because we are undergoing, you know, major pandemic crisis in most parts of the world, right? And so you can see that, you know, disruption of healthcare, they do have real world consequences. People actually die from disruption of healthcare infrastructure. So the key thing is that, you know, these threat actors, whether they're state actors, they're non-state actors, they seem to operate with impunity. And there doesn't seem to be any rules to stop them. So I was talking to different governments, they actually asked me questions like this one here, right? Can state actually invoke international law or norms to deter attack against healthcare infrastructure? Now let's take a quick analysis of where we stand when it comes to international law and norms on infrastructure, healthcare infrastructure, or critical infrastructure in general. Now, in terms of international law, we do have the IHL, International Humanitarian Law, and IHL has special protection for medical facility and personnel. IHL also has this cardinal principle of distinction, that is, you have to distinguish at all times between civilian population, combatants, and between civilian objects and military objectives. The challenge here is, of course, you know, IHL only applies in armed conflict. And we are not, at least the countries that I'm talking to now, we are not in an armed conflict. So how does that apply for these critical infrastructure and medical facility, et cetera, et cetera? But then if you look at peacetime law, and you know, there's also no explicit mention in the UN Charter, in the general international law, et cetera, et cetera. So how do you go about, you know, invoking international law as such? Right? What about norms, right? And norms of responsible state behavior in cyberspace. The first speaker talked about the UNGGE, right? And so UNGGE basically has put in place its position in there. I know the ICRC also supports that position. And you just saw that private organizations like Microsoft is also trying to shape norms of responsible state behavior in cyberspace. Now, the challenge with norms, as I see it, is that norms take a long time to work. It's also non-binding, it's voluntary, right? So if it's being triggered, if the norms is being triggered, there's actually no remedies that you can, you know, enforce in place. So as I speak to different governments, they say, well, how do we go about resolving this issue here? It's not so clear in international law, the norms will take a long time to work. And my answer is very simple. I say you have to look at the spirit of international law for us to get the guidance, right? So if you think about this in an armed conflict scenario, we know, for example, that the IHL strictly prohibits attack on medical facility and personnel. And of course, you know, civilian objects as well. Even if they convey military advantage, right? So the key word there is this, that is, even if they convey military advantage. You cannot do it. So if you cannot do it, even if they convey military advantage, then, without any question, this prohibition has to extend to peacetime, right? So, you can think about it. You cannot do it during wartime, because even if that gives you military advantage, that spirit has to extend towards peacetime. So prohibition has to extend towards peacetime. Now, the challenge is, of course, states have to, come up and articulate how different bodies of law actually apply, like sovereignty rule, which is highly contentious today. I'll come to that later on. Things like prohibition on intervention, use of force, right? How do all these different rules actually apply when it comes to, protection of critical infrastructure or medical facility during peacetime, right? So going back to this, is this a good thing, right? And going back to this point number one here, this is, to me, I'll give you my two cents on this. I say it's questionable. I've told Microsoft my opinion. I've met with them over conferences. I say, look, this is a norm that you're trying to shape during peacetime, where you let states to have the option of opting in or opting out, right? And I just articulated the fact that, this prohibition of attacking critical infrastructure or medical facility has to extend over peacetime. So if you let states opt in and opt out, you're actually going to be diluting what's actually happening, right here, the spirit of international law, right? So I say it's questionable. And I told them, I think you should change that somewhat, right? Not letting states have options to come in and come out of this here, right? So that's it. So this is private sector's part of it. But before I go to the next lessons learned, this will be an example whereby, we are leveraging what is actually known, what is actually clear in an armed conflict scenario. And we try to extrapolate or extend that towards peacetime. Now, sometimes the reverse could work as well, particularly when it comes to, things in armed conflict that are not so clear. But, we will try to work it in peacetime so that it may shape our understanding or the state's positioning when it comes to armed conflict scenario. What could be an example of this, right? And this is the example of, in IHL, International Humanitarian Law. This concerns the status of data as an object, right, in armed conflict. Now, I'm gonna just give you a quick run through. I do not assume that everyone knows the debate, right? So I try to shape it in a way whereby, everyone here can I can give everyone here an overview of what is the issue here. So the question here is data an object, right? The majority experts' view is, of course, no, because data itself is intangible, right? However, many experts actually, agree that, if you have a cyber operation on data, and this operation actually result in damage or loss of functionality of civilian objects, this is considered unlawful, right? So the main debate is this, that is, what if operations on data does not result in attack on civilian object? And attack has got a specific meaning in IHL, so you can look it up. And so the main balance here that I think most experts are trying to make is the balance between what is military necessity and what is humanitarian priority, right? So to give you an example, if data is an object, then altering data for psychops or psychological operations during armed conflict on civilian would be unlawful. And militaries would not accept that. How can I not engage in psychological operations? However, if data is not an object, okay, what that means is that banking data, medical records, tax record of civilian can be altered. So potentially this could be highly disruptive, and there's going to be human cost involved because we are moving towards a war that's highly dependent on data, digital records. So I actually take the position as I speak with government that data must be an object. We have to take that considering what's actually coming. And I was actually happy that I saw that France also adopted that position, that data is an object. I also know that ICRC has put out a positioning paper, with the same alignment as well. So while this debate is actually going on, right? Now, this is the armed conflict scenario here. I think there are things that we could do that would, in peacetime, that would shape the understanding of how things could work out in the armed conflict scenario. And I was actually pretty impressed with this. You may know this organization called the Carnegie Endowment for International Peace. They have a proposal for the G20 to promote a global norm towards manipulation of the integrity of financial data. As you know, if you have disruption of financial system in one country, it's not just that one country that's going to be affected because of how interconnected we are in the financial world. This impact will be cascading throughout the entire world here. So I think, if I have to look at this, I think this has a good chance of, G20 adopting it. And by the way, for any global norm to be in place, you absolutely have to have the G20 in place. You got to have, important countries like the US, China, Russia, right? All the key countries have to be on board for this. So I think this has a good chance of, shaping the norm in terms of, manipulating integrity of data. Hopefully, it has the capability to also shape how states think about, the status of data in an armed conflict scenario. All right, so I want to now speak a little bit about media and media narratives, right? So this is going back May 2019. I saw this headline, this is the Washington Post. It basically said that Israel responded to Hamas cyber attack with an airstrike, right? And of course, then there are other headlines as well, mostly around the same thing, that is Israel responds to cyber attack with airstrike, as well. Then you see that the Twitter page of Israel Defense Forces, or IDF, basically explaining, we stopped the cyber offensive against Israeli target following our successful defensive operation, cyber defensive operation, and we actually bombed that building, right? So this is the narrative that you see here, that is, responding to a cyber attack with a use of force. So a lot of questions actually come up in the media to say, well, is this proportional? Can you actually kill someone, and who's trying to hack you, right? And so this idea, this narrative of proportionality is basically flooding the whole, media space here. I actually looked at this and I was like, this must be totally wrong, the way the narrative has been constructed, right? And unfortunately, it's already out there, right? So the way you have to look at this, in my opinion, is that when something like this happens, you have to look at which body of law actually applies here, right? Is this jus ad bellum, which is basically criteria that you actually consult before you actually use force, right? And I suggest that's not the case because Israel and Palestinian, they are in an armed conflict. So when they are in armed, we know that they are in an armed conflict because international humanitarian law applies, right? So the key thing to ask here is that the people that they targeted, are they combatants, right? If they are combatants, then it doesn't really matter what they do. I mean, they could be hacking you, or they could be driving to work, or for all that matter, they could be sitting on the toilet. You can still target them, right? Because they are combatants, right? So this, what's actually more key to ask is that, did they take feasible precaution when they were targeted? And yes, there's also a question of proportionality, but not in the way that the media is actually framing it, but it's more towards collateral damage. And i.e. asking the question, did the military advantage that the Israeli Defense Forces gain outweigh the harm to civilian, right? So I'm actually very concerned about the narratives here. I think it's totally wrong. And so I was I regretted that I actually saw this piece of news 2 days after it came up because I was so busy doing so many different things. And I realized also that my ex-company also put up a positioning paper that speaks to the same thing. That is, is this proportional, things like that, right? So I wrote a long email to my management. I said, explain this narrative is actually wrong and you should not have that in place, right? But because, I actually saw that later and it's so hard to actually pull things back. In fact, a week later, I was up in Germany. I was speaking to a journalist of a very respectable, news media. They are like the New York Times of, Germany. And so I explained to the journalist, I say, you cannot have this narrative in place. Can you, publish something to rectify it, right? And the answer that was given to me was, well, if we publish the correct version of this event, how to look at it, then there's not a whole lot of sensation anymore, right? So my editor will not allow this, right? So this is the key thing. That is, as you look at media narratives, you have to be concerned about, who is talking, and you really have to drill down into the details to say, is this narrative correct, right? So that's that with the media. Now I want to talk a little bit about deterrence. If you live in the Western world, in Europe, NATO countries, and in the US, deterrence is constantly on the minds of different states, right? So the way to look at deterrence in a layman's term is to say, here's the line that you try to tell your adversaries not to cross, right? Here's the line, do not cross it. If you cross this line, then bad things will happen to you, right? So deterrence is roughly that, right? You can actually go back to 2017, right? So I've been involved in NATO Cyber Operations Center since the beginning. And you can see that the Secretary General of NATO basically talked about, invoking Article 5 of NATO. This is basically the, attack on one state is an attack of all, is the collective self-defense, treaty, right? And then you can see that in the US, Senate testimony, Mike Rogers, who is the ex-director of NSA, basically talked about deterrence as well. And you can also see more briefing in the House Armed Committee. The word used is deterrence, 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 deterrence. Of course, you can even move back further. The US Department of Defense cyber strategy, in going back 2015, has deterrence all over it as well. And so is the White House cyber deterrence policy, right? If you read that, more and more deterrence will actually come up. When Trump came into the office, deterrence is there as well. Senators demand a cyber deterrence strategy from Trump. EU has that as well, right? To declare cyber war, cyber attacks as act of war, deterrent is being invoked. The UK, going back 2016-17, in this particular paper, has also got deterrence all over it. So I'm always puzzled. I say, why is deterrence such a big thing when it comes to how you defend your cyber infrastructure here? And I suspect it has to do with how our international security architecture is being architected, right? Why the dominance of deterrent? Because if you look at the security architecture, it really has got these lines built in, right? It's got this, deterrence being built in. And so this example here, talks about two thresholds: use of force threshold, armed attack thresholds. And, you can see that they're actually being put in place to convey to other states to say, do not do this. If you did this, something would happen, something bad will happen to you. Now, I actually am not sure. This is a major interest for me. I'm not entirely sure if deterrence is the right strategy to use in cyberspace, but I know that, for deterrence to work in cyberspace, it has to fulfill at least 3 criteria here. The first thing has to do with recognition of sovereignty. And today, when it comes to cyberspace, this is highly controversial, and I'll speak to that more later on. Second is attribution, right? That is, for deterrence to work, you have to know who did what to you and why, right? So attribution to threat actors must be possible. And for deterrence to work, of course, rules should be made clear. So I'll leave deterrence for a while and then talk a little bit about sovereignty at the end of the presentation. But for now, I will move on to the next lessons learned. And I've seen this plenty of time, and that is that it's one thing to have a manual, and some of you, I'm sure, have gone through the manual called the Tallinn manual. This is version 2.0, and I know most of the people who wrote the manual as well. And I can tell you that I have been in a number of scenarios or simulations with lawyers and technical people. It's one thing to have this manual, but to apply it is extremely challenging, right? So we're not just talking about legal people who just graduated from university, and these are the people who basically approve airstrikes, for example, right? And they have difficulty applying the law here, right? And part of the reason is because, as they are an expert in, international law, but their lack of understanding of how cyber operations work prevents them from applying that properly. And then you also will have, let's say, technical people who are very strong technically, but their lack of understanding of how the law actually applies also proves very, very challenging as well, right? So there's no easy way around this. There's no shortcut. There's going to be, things that you have to do, right? If you want to be able to apply the law very well. And that is, you got to, constantly simulate scenarios. You think about what's actually happening now. You think about possible scenarios following that. You constantly simulate that. And you potentially will have to do cross-training. That is, the technical people who are trying to help the legal guys, they have to know more about the legal side of the house as well. They need to have that sort of a training in place. And likewise, the legal people, they will need a lot of understanding on how cyber operations actually work as well. So cross-training is going to be super important going forward. Right? So number 7, cyber, a different domain. I think going forward, how we are going to be thinking about harm will need some sort of adaptation, will need some changing in place, right? Because for the last maybe 60, 70 years, the way we've been thinking about harm is these harms is, they all have violent consequences. In fact, if you read IHL, the words that they use is basically injury and death to individuals and destruction to property, right? So as the conflict intensity goes higher and higher, then correspondingly you have more harm, right, as a result of these violent consequences. But I think it's important to realize that as you move forward with cyber, if you throw cyber into the equation, then we're not just talking about violent consequences. You have the combination of both violent and non-violent consequences, right? And this is more than just injury and death to individual or destruction to property. Here we're talking about how cyber can be used to undermine, let's say, your economy, your political system, the way you look at foreign policy, right? Social system and cultural aspect of your country as well, right? So if you add that, if you take into account all that, potentially the harm that's actually happening to your state is much higher than you originally thought or what you originally used to, right? And so, as you look at this, as I encourage different governments to look at this, they may have to do some adjustment, including maybe looking at the threshold and say, maybe we have to, the use of force and armed attack threshold, you may have to make some adjustment right there as well. So you may have looked at how, let's say, the Netherlands and France articulated their position. And you see that, they have already included in relation to use of force and armed attack, potential harm to their economy, right? Done with cyber operations. So this is a key thing I think we need to remember as states looked at how to position themselves when it comes to international law. This is the second last lessons learned, but it is super important for me. It's near and dear to my heart. I have spoken about this in many conferences, including NATO conferences. And this has to do with the question of sovereignty. Going back 2018, the person that you see here is the UK Attorney General, Jeremy Wright. He's no more the Attorney General, but at that time he was the Attorney General. So in the Chatham House, meeting or briefing, he basically articulated UK's position, right, on how international law applies to cyber operations. So I was following that speech, really well. I think I mostly agree with everything he said, until this part here that I found very, very problematic. And maybe we can read this together. And he basically says, sovereignty is of course fundamental to the international rule-based system, but I am not persuaded that we can currently extrapolate from that general principle a specific rule or additional prohibition for cyber activity beyond that of a prohibited intervention, right? So basically he says, the UK government's position is therefore that there is no such rule as sovereignty as a matter of current international law. So to summarize, what he's basically saying is that sovereignty exists as a general principle, but not as a rule. I fully disagree with the UK on this positioning, because I think it's wrong. It's wrong because I think there's abundance of state practice, there's abundance of state opinion jurists, and also abundance of case law that continues to affirm that sovereignty as a rule exists right here. Now, I don't just oppose the UK because they are wrong in here, but I think if the UK has its way, that sovereignty is not a rule, it will be bad for everyone, especially it will weaken the smaller states. I don't have time to walk through the analysis here, but with governments, I'll sit down and say, this is why you should oppose this, because it will weaken you as well, right? Now, I can of course understand why the UK may be taking that position, right? That is, if there is no rule called sovereignty, right, then the UK then can say, then we can do stuff to other people, right? We can do stuff to other people without violation of any rules, right? And so that is great. But remember this, as I told different governments, I said, just as we can do stuff to others, so can others do the same to us, right? And so this is going back May 2018, and interesting enough, maybe 5-6 months later, UK National Cybersecurity Centre, NCSC, which is part of GCHQ, put out this report saying, a very comprehensive report called Reckless Campaign of Cyber Attacks by Russian Military Intelligence Exposed. So I went into the, this website here, this page here, and looked at all the cases that they have outlined that were attributable to the Russians, right? In this case, the Russian military intelligence. I have to tell you, I'm very familiar with most of these cases here because I was in that former company and we actually worked these cases as well. As you read through the report, you also have this line on the right side here that says, these attacks have been conducted in flagrant violation of international law, have affected citizens in large number of countries, etc., etc., etc. You can actually look at the link right there when you have the time. So as I looked at this and I say, well, violation of international law, the UK is actually accusing the Russian of violation of international law. So it's not just, one thing to say, yeah, this is a violation of international law, but what's more important is to ask which rule in international law that was being violated. And as I look through all the cases right there, I say, the only rule that is possible for violation is the sovereignty rule, right? But wait, the UK Attorney General just pulled out that rule 6 months ago, now they're accusing the Russian of violating the same rule that they actually pulled out 6 months ago, right? So if I was the Russian, I would say, yeah, I did all that, but I don't see why that's actually wrong, because you actually said 6 months ago that we could do all that, right? So key thing to remember at the beginning, right? Just as we can do stuff to other people, so can other people do the same stuff to us, right? In the spirit of sovereign equality. In the last lessons learned, I'd like to speak about intelligence, right? I noted, for example, how critical intelligence is when it comes to the question of deterrence. That is, you've got to know who did what to you and why they do that. And I think, over 27 years in the private sector, I can see a really strong case for collaboration between the government and the security industry when it comes to intelligence. Let me explain why that's the case. I came from a private security company. I know how many threat groups that that we track, and I can tell you it is in the thousands, right? So there's so many threat groups around the world, and we're looking at thousands and just tracking their TTPs, right? Tactics, techniques, and procedure. So from a private company perspective, private company usually have, that breadth right there. No government comes close. I've known so many governments and understand how they work. So no governments have this sort of a breadth of thousands, tracking thousands of threat groups. But what governments do not have in breadth, they actually make it up in depth, right? And that is to say that, if they focus on the threat group, they can use their tools of national power to actually go deep within the threat group, right? And try to uncover even more things right there. And this is why I say that, this collaboration is going to be so key, right? Between the government, which possesses the depth when it comes to tracking, threat groups, but also private companies where they have the breadth right there, right? So this combination of depth and breadth is going to be so key. So I think, as you are helping to formulate your national security strategy or national cyber strategy, or even evolve it, please, please include the private sector as part of the, the things that you have to do going forward. With that, I would like to thank you for your time. I would like to thank you for your attention. I hope this has been somewhat interesting for you. Rohit, am I on time or am I way out of time?
No, you are perfectly on time. So
I am perfectly on time. Okay, I'm glad to hear that. All right, cool.
Thank you, Kah-Kin. So thank you for this comprehensive presentation. So I think you touched on a number of interesting areas that has been kind of evolving from the role of the private sector to the role of the government in the forming the cybersecurity governance. I think it's quite interesting to hear, as you said, how the states have been kind of retaliating in terms of how they are conducting the cyber operations. And you have also touched on how the media is shaping the narratives on the cyber attacks, and also you touched about the importance of deterrence as well, how it has started to come as an important kind of strategy for the cyber defense. So you touched on a whole kind of gamut of interesting phenomena that has been evolving. So there are some questions that have come up. So maybe I will ask the participants to ask directly. So there are a couple of them. So maybe Jinghua Liu, he wants to ask the question. So floor is yours.
Yes, thank you very much.
Yeah, please.
I'm having some trouble on my hands icon, so I have to talk to you first. So firstly, thank you the two speakers for the excellent presentations. I really appreciated them. So I have two questions and a comment. The first is to Mr. Komiyama. You mentioned that the third group don't really care about the political insights, and you also ended up by saying that people can, any other experts can trust you as the individual to share information. But my question is, in the past few years, do you think the political tension are not affecting the collaboration between experts? I've heard a lot of complaints, and also even though you're individually a very trustful person, it means that all the collaboration can just go forward as before. So the second is to Mr. Ho. I think it's very interesting to hear how you talk about whether data is an object and whether that can influence the setting up of norms. As far as I know, normally in the international law area, people use two ways. One is effect-based, or another is tool-based. So do you think this is just another measurement like a target-based? And also, I remember that in the US cyber strategy, they always use a way like we defend against or we fight against those cyber attacks with significant consequences. So it's more like they are using the effect-based approach to see whether the activity is an armed attack. So I'd like to hear your opinion on it. So
okay.
Thank you for.
Thank you for your question. So maybe we could go first with Dr. Koichiro, and then we'll move with Mr. Ho.
Thank you. Thank you, Jinhua, for your question. Let me I'll say very briefly. It's the fact, and the CSAT community all understand the political tension associated with all the militarization of cyberspace. We CSATs have been how do I say have been becoming less cooperative to each other. When very good example of this is first, Forum of Incident Response Team, supposed to be a global alliance of CSAT. But 2 years ago, 2 years ago, because of the US economic sanction to Chinese vendors like Huawei, DAFA, ZTE, the CSATs of these three companies were the member of first. However, the sanction prohibit the exchange of information between US entity and those companies. So with that circumstance, first decided to suspend the membership of these three Chinese companies. So we clearly feel the pressure or tension, and some of us, like myself, is very frustrated with this situation. However, we don't have any good solution right now. That's it. Thank you very much.
Thank you, Dr. Koichiro. So maybe Mr. Ho, you would like to respond?
Sure. Thank you, Jinhua, for your question. Actually, your question brought up a memory that I had on a conversation going back 2010 in NATO headquarters. I was sitting in the office of the general manager for NC3A. And NC3A is NATO Consultancy and Command and Control Agency. I think that's what it stands for. It doesn't exist anymore. But anyway, I was asking the general manager of NC3A, I say, well, do you think cyber itself can generate the sort of Article 5 or use of force or armed attack or Article 51 UN Charter scenario. And at that time, his answer was very simple. He said, well, look, cyber is basically these zeros and ones, right? And, if you look at Article 51, we talk about, armed attack. Armed attack is, bullets and guns and missiles and bombs and all that, right? And so at that time, he said, well, I don't think cyber will ever come to this scenario where it has the, you cannot compare that to missiles and bombs. But I think, looking back and seeing where we are now, going back to 2021, right, which is where we are now, some 10 years later, many things have changed, right? We know that, these are all zeros and ones, but these are zeros and ones that we depend on for our life. And these zero and ones have real life consequences. And that is to say that, people can actually get injured. People can die from this thing here. So in looking at the law itself and how to interpret international law, I am very, very much in favor of looking at effect-based consequences. And that is to say, irregardless of the tool that you use, irregardless of the weapons of choice, right? It doesn't really matter whether it's chemical, biological, cyber, traditional bombs and missiles. But what really, really matters is, what sort of effect or consequences that you have on, let's say, the people, right? The civilian population and how they actually will suffer going forward. I think that has to be the guiding principle for me, at least, going forward. Thank you.
Thank you, Mr. Ho. There are a couple of more questions, and one question that is in the chat box. So maybe it's Mr. Ho, you could answer that. Let me read that question for you.
Sure.
So
is it in the chat box already?
Yeah, it's in the chat box already. Okay. So it says, on state attribution issue, even some states are attributed as a malicious actor. Except unilateral US or multilateral EU sanction, can arguing state go to international court to ask damage compensation with non-convincing evidence? So maybe you could answer that question.
Sure. Can I just read the chat one more time? So I.
Yeah, sure.
Let me just quickly read it. So except can arguing state. You mean can the victim state? I suppose that's the question, right? Can the victim state go to international court? And I suppose this international court is the ICJ, the International Court of Justice, to ask for what compensation? Okay, victim state with non-convincing evidence. Okay, now it's unlikely you go there with a non-convincing evidence because it is the International Court of Justice. And first of all, as you move to ICJ, you have to basically articulate what rules of international law that have been violated. And you've got to make the case for that as well, right? So is this the sovereignty rule? Is this about the prohibition of intervention? Or is this the, the use of force rule, Article 2.4 of the UN Charter? And so you got to be actually clear in terms of, what was being violated, who did what to you. So there is actually a standard of proof that has to be in place, but I wouldn't say the standard of proof is like the criminal court, right? Criminal court, we use the standard of proof called beyond any reasonable doubt, right? You have to have some level of proof right there that you have to put in place. Hence why I say that for deterrence to work, right? One part of deterrence is, of course, the legal part of it. You have to have an ability, a strong intelligence capability to understand who did what to you. Now, you may, of course, go to ICJ and argue your case, and because of intelligence sensitivity, because you do not want to review your sources and methods, may still limit what you present, but at least you have to have some level of compelling case, to go forward. That will be my answer right there. And I see there are more chats coming in. Is this for me or?
No, I think it's maybe Maybe should I ask Jinua who to take the floor to ask the question? Would that be okay?
I asked me to use the question again.
Oh, sorry, it's Jinua CHO. That's what it has been written in the name. Jin Yun Cho, right? Sorry. Would you like to take the floor to ask the question, or?
No, I'm okay. Well, Mr. Ho answered right way, as you mentioned, the well, sensitivity or some compelling cases will be some consideration for the bringing that internationally wrongful activities to the International Court of Justice. As you mentioned, was the SOP, standard of proof, will be, as you mentioned, beyond the doubt. It means it is one of the highest level of
no, I didn't say that. I say it's not like the criminal court where it's beyond reasonable doubt. But you still have to make a compelling case.
However, I'm not sure. Some victim state may have some interest to disclose all the classified intelligence to the public. So it means that it will disclose some intelligence gathering and analysis capability to the whole world. They will not do that in a way. Yeah, that is my understanding, and you have a point for my question. Thank you.
Yes, so just to reiterate, the reason why it's not beyond reasonable doubt is because, you at least have to make a compelling case and understand, of course, that intelligence matters are sensitive, as you mentioned. You do not want to reveal your sources and methods. So you do the extent possible to make a compelling case, right? So there's no, this is the line that you have to meet as such, right? So you have to have a compelling case that the judge can actually look at as well. So I see one question here.
Yeah, there's one more question from Dr. Yeah, could you see that question, or do you want me to?
Is this about the French position on data? It's a military object.
No, before that, there's a question by Dr. Yoji Kazi. So he asks, like, following your effect-based argument, should cyber attack be handled by deterrence by punishment? And he writes in the bracket offensive, or by deterrence by denial, and the bracket defensive. Should it, and he also says, should it be also made by the Article 5 of collective defense of NATO or Japan-US alliance?
Wow, this is a loaded question. Okay, let me try to answer this. I spent, as I explained in my bio in the past, right? I spent lots of time studying counterterrorism, and I note that, for example, in counterterrorism, especially the conduct of the U.S. and the allies, sometimes may be missing the point in terms of their response. Right? I'll try to draw that parallel to the cyber war as well. When you look at an adversary, right? So there are three things that you have to be concerned about as you handle the adversary. One is, of course, you can look at the adversary and say, hey, you attack me, or before you attack me, I attack you, right? So this is the, looking at the adversary's capability and try to disrupt their capability. The other two dimensions, and I explained this in the NATO conference going back 2019, that I think we don't actually see a lot, would be the legitimacy dimension and also the need dimension. That is to understand on the need side, what do these adversaries actually want and how do we cater for that want, right? And that's one part of that. But then there's also the dimension of legitimacy. That is, how do we delegitimize, the action of this adversary? So you got to look at the whole spectrum, right, between legitimacy and what is the need of the adversary and the capability, and then start to decide which one of these actually makes more sense, right? Makes more sense not just for today, but makes sense again for going forward. And so in counterterrorism, what you often see is, of course, for US operation, in the Middle East, it's always about, pulling people out and shoot them in the head, right? So it's always about how you attack the capabilities of these terrorist group. But very, very little attention is actually focused around, how do you delegitimize the work that they actually do? So go back to this same question here, right? That is, if you are faced with a scenario like this, is it about, attacking the capabilities of your adversary, or should you invoke, the legitimacy of the adversary as well? These are questions that you have to answer, and this is a national position, I would say. But I would say, and the reason why I think we have not done a really good job going forward is on the legitimacy side, is that states have not come out, right? There are maybe 15 states that have come up and articulate what are the rules of international law and how do they apply to cyber operations. Going forward, I hope to see more and more. I think this will, increase the bar going forward.
Thank you, Mr. Ho. There are a couple of hands were raised. I think Professor Fan, would you like to ask any questions here?
Yeah. First of all, my sincere thanks to Mr. Komiyama and Mr. Ho. Thank you for your wonderful presentations. I think I have learned a lot from them. I have one question is that, so nowadays some country have established powerful cyber operations forces, and also hold military exercises in cyberspace operations. So I don't know now in the world, is it legal for countries' armed forces to conduct military operations in cyberspace? Because nowadays, if you conduct military operations in cyberspace, that means you interfere with the other country's sovereignty, and also endanger the security, the cyber security of the other countries. So I don't know whether there is some international law or norms to govern this kind of operations. Thank you.
So, thank you for the question. So maybe I would request Mr. Ho to respond, perhaps.
This is a tough question to answer, and it depends on who you ask. They will give you, even in Europe here, for example, that if you ask the NATO guys, they give you one set of answer. But then if you go to the EU guys, they'll give you another set of answers as well. But I'll give you my perspective, right? First, I think it's counterproductive when you have militarization of cyberspace, right? So, and because, most of cyberspace is used by a civilian, right? People like, you and me, and we use it to conduct our lives and, to promote our economy, to, for the general well-being of the society and all that. So I think from my perspective, it has to be, a predominantly used for peaceful purposes. But the reality, of course, is that we live in a world where, geopolitical tensions actually matters, right? So that is to say that, states are constantly trying to exert influence on other states, but they are also at the receiving end of influence from other states as well, right? And so when they look at how to respond, they have to say, hey, what are the options that could be on the table, right? And so military options in cyberspace could be one option. And that's really, really, really hard to deny it, right? So I do not want to be naive to tell you that, yeah, I know it's not gonna, the ideal world is this, that there is no militarization of cyberspace. There's gonna be some, I think, to some extent. Hence why, if you look at international law, the Geneva Convention, the 4 Geneva Conventions go back 1949. The additional protocol only came in 1977. So between then and now, there is no, you cannot just read this international law and say, hey, where does it apply to cyber space? Hence why it's so important for states to, come up and articulate how these laws that were created 1949, 1977 actually apply in today's world. Because if you do so and you do it right, and in itself, it will give you a sense of deterrence, right? To say, yes, you can conduct cyberspace activities for the military, but be careful about, infringing on the sovereignty of another country, right? I gave you the example in my presentation about the UK, right? The UK, I speak out against them all the time. I say, this is really bad that you actually put it up this way, right? Because not only you are infringing on the sovereignty of other country, right? You actually make every one of us weaker by this positioning as well. So I think, there's going to be effort from the rest of us to hold states accountable as they put up positions like this, right? Going forward. If you want to have a better future, it's going to be how we are going to be working better together. It's not going to be, it's the Chinese is doing this, we should not do this with them, or the US is doing this. It's going to be how do we resolve this problem together.
Well, thank you, Mr. Ho. Perhaps we could take one last question. So there was one in the chat box which says that, could you elaborate the French position on data is a military object? So it's a question asked by Dr. Koichiro.
The French position, let me just read that, okay?
Yeah.
Okay, I see that. So the French position on data, so going back to just to clarify on the data, this data as an object concerns more on the civilian side, okay? Not really of the, so, your question is, is data an object? Is it a military object, right? And so you brought up the question of, let's say, a bridge. Is this a military object that is actually used by civilian or military personnel? I think in IHL classification, once you designate an object, you cannot have a two destination, right? So a bridge can be both used by civilian and military, but once you designate that as a military object, that is a military object, and of course, you can actually attack it, right? Subject, of course, to things like principle of distinction, principle of feasible precaution during attack, and of course, proportionality principle that talks about collateral damage, right? So it's not really that question right there, right? That is it a military object or civilian object? Right? So the French position is more towards, you have data as an object. You do not want, if you comply with principle of distinction, that shouldn't be a target, right? So for example, you may think about medical records of population during armed conflict. Do you want to target that, right? It doesn't, it may not result in an attack in IHL sense, but do you want to target it and change that, right? If data is not an object, then you can of course target that, right? Because it's not an object at all. But if it's an object, then you have to think twice about this being a military object as such. That's why the bar itself is actually higher as such. So I hope I clarify your questions. If not, then just shoot me an email, then I'll clarify more.
Thank you, Mr. Ho, for kind of answering all those kind of questions. Of course, those questions are very interesting and very kind of very thought-provoking as well. But of course, I mean, you kind of addressed most of them. So of course, there were a couple of more questions, but I think for this session, we would close this session, and I would like to thank both the speakers who presented during this session and also provided the Q&A. So I think moving on to the next session, we'll be discussing more with more from the IHL, more from the ICRC perspective. So maybe perhaps we could take a quick 10 minutes break. So and then we could reconvene after that. So Thank you to both the speakers once again. Thank you.